A proper estate plan helps you manage what you own and creates a legally binding plan for your loved ones to follow. You get to name the people that you want to make important decisions if you become incapacitated or die. If you haven't made a plan, the state has one for you, and it may or may not be what you want. We can discuss the state's plan and see which way to go. It's about life and death. Your plan should be about life as well as death. I can explain what makes a proper plan in plain English, or at least plain English translation of the legal terms. What is an asset? An asset is anything you own that has monetary value. Assets include personal property such as art, vehicles, electronics, and jewelry. They also include real estate or land, IRAs, 401ks, investment accounts, bank accounts, cash. Business interests and life insurance are also assets. What is a beneficiary? A beneficiary is someone you choose to receive an asset when you die. You name beneficiaries in your plan, whether it's a will or a trust, or with your financial institutions. What is a durable power of attorney, or a POA? A durable power of attorney gives someone that you trust the ability to sign your signature while you are still alive. Now, although it is intended to be used if you become incapacitated, it can be for several other purposes while you're not incapacitated. The person you choose has the power to make investment decisions, pay bills, and sign legal documents. What is an estate plan? An estate plan is a set of documents to take care of you and your assets for your life and for several years after you die. A proper estate plan takes into consideration your family situation and age of your children, your assets, your health, and wishes for what you want to do with your assets when you die. Documents used in a proper estate plan include a revocable trust, a will, a power of attorney, living will, designation of medical surrogate, designation of guardian for minor, and other documents necessary to make sure your plan is funded. What is funding? Funding is a term usually associated with a trust. It's the process of transferring your assets to the trust. Now, this is done by changing the name of your bank accounts, brokerage accounts, and other assets. You can also fund your trust by naming it as the beneficiary to your life insurance, your IRAs, and your 401k type accounts. You can also do that with your bank accounts. They usually call that a pay on death or a transfer on death as opposed to a beneficiary. If you tell your bank you want to change your beneficiary, they'll understand. It is important to know when and how to do this, and I highly recommend speaking with an estate planning attorney to make sure this is done correctly. What is a guardian? A guardian is the person who will take physical care of your minor children if something happens to you and you're not able to physically care for them because of an incapacitation or death. The guardian you choose has priority with the court. Now, if you don't choose a guardian, the court will choose one for you. It's important to select a person who will provide the best possible care for your children. It does not need to be the same person in charge of financial decisions. You should also have a backup and a short-term guardian if your selection lives out of the area. Guardians can also be for elderly people or adults if they ever become incapacitated. It creates a need to go to court and have one assigned to take over the responsibilities for the adult. What is a designation of healthcare surrogate? A designation of healthcare surrogate is a document that appoints someone to help make medical decisions if you're not able to. It's also called a medical power of attorney in some states. In selecting this person, you should have conversations about various medical situations that could arise so they know what you would want to happen. Your healthcare surrogate is only for healthcare purposes. If there's a financial issue related to the care, your surrogate would need to coordinate with the power of attorney who has financial powers. What are heirs? Heirs or heirs at law are determined by the law of your state. It's the state's plan for you. They're used when a person does not have a legal plan or has failed to designate beneficiaries on financial accounts like like 401ks, IRAs, life insurance, and bank accounts. Florida's system of heirs is very extensive. Here's the order of priority. Number one, spouse and children. Percent varies depending on if the child is from another relationship. Number two, children if there are no spouses. Number three, parents. Four, siblings, that's your brothers and sisters. Five, nephews and nieces. Six, grandparents. Seven, aunts and uncles. Eight, cousins. Nine, distant relatives. If none, then relatives in the same order to the last deceased spouse. If none, then most likely to the state. What does it mean to be a joint owner? Well, if you own assets with one or more people, you have joint ownership. You may have a bank account with another person on the account. You could own real estate with someone. Your house can even be owned by you and anyone. Joint ownership is different than designating a beneficiary or having a signature authority on an account. Although joint owners are usually spouses, they can include children, siblings, parents, business partners, or even friends. When you die, a jointly owned asset usually goes to the remaining joint owner. There are exceptions depending on the asset, so it's important to understand what happens on your specific asset if one of the joint owners dies or becomes incapacitated.